Hello and welcome to another segment of Western Wisconsin Journal. I'm Jamie Johnson, attorney with the Lohman Abdo Law Firm here in Hudson, Wisconsin. And I do the legal and government topics for Western Wisconsin Journal. Today, we are going to be interviewing a candidate for the district attorney position in St. Croix County. I want to welcome my guest today is Amber Hahn. Amber, welcome to the show.
Thank you, Jamie. It's very nice to be here.
And Amber, you are running for district attorney. So before I ask you why you would ever do that, why don't you talk a little bit about your background? Because as a candidate running for office, that's one way that they want to be able to get to know you. So what is it about? What makes Amber Hahn? And then we'll later get into your qualifications and some of your experience. Okay.
Sure. Thank you. So to start out, I grew up primarily in Northwest Wisconsin. I did graduate from high school in Chippewa Falls Senior High School. Both of my parents would be characterized as blue collar. I was the first person in my family to get a college degree. And after college, I went on to law school. And after law school, I worked for a brief period of time for People Against Domestic and Sexual Abuse in Jefferson County. And then I was hired by the St. Croix County District Attorney's Office. I worked there from January of 2009 until June of 2015, at which time I took a job opportunity to work for the Republican Attorney General Brad Schimmel here in Wisconsin in the Madison office. And I went there to do prosecution and litigation on a statewide basis. So I practiced as a prosecutor across the state of Wisconsin. I think in my 5 years at the Department of Justice, I visited about 16 counties where I handled cases there. I also was the Assistant Attorney General assigned to the Sexual Assault Kit Initiative for about a year, which was, if people don't know, the backlog of untested sexual assault kits. And I worked as the attorney for that project for about a year. And then in April, after about 5 years at the Department of Justice, I became an assistant district attorney in Dunn County, and that's where I'm currently employed. And I've been here since April, and our family moved back from Madison to River Falls. I am a mother of two. I have a daughter who is going to be starting kindergarten this year, and I have a son who is 3 years old. So we're really excited to be back in St. Croix County as our kids start into the public school system. And we're planning to be lifelong members of the community.
Excellent. So with that, you mentioned your background and certainly your experiences. What do you think about those experiences you mentioned prepares you to be the head district attorney in St. Croix County?
It's a really good question. On a couple different levels, I think my experience aids me in the role of district attorney. On one level, I've had the opportunity to do a lot of different types of litigation. I've litigated over 50 jury trials, and I've done those jury trials in approximately, I think when I counted, about 12 different counties. So that's been different court systems, different judges, different jury procedures, and I've done pretty much every type of prosecution. You can think of everything from traffic litigation to sexual assault litigation, both adult and child victims. I've litigated homicide cases. I was one of the prosecutors on the Russ County deputy Daniel Glaze, who was shot by Douglas Netek. I also was co-prosecutor on the state of Wisconsin versus Aaron Schaffhausen, which was the St. Croix County case. And so I've had a lot of different experiences doing complex litigation, which I think really assists me in leading a district attorney's office. I also think that the experience that I've gathered really assists me in relationship building. I've met a lot of different people during my career so far. I've worked with law enforcement and attorneys from all different counties in the state. I've seen really great law enforcement. I've seen law enforcement with some problems. I've actually prosecuted law enforcement officers in my role as Assistant Attorney General. And so I have learned a lot from that experience. I have also had the opportunity as an Assistant Attorney General to work with the legislature At DOJ, we were often called upon to provide input on legislation. My area of expertise was drug cases, so I participated in some of the hemp legislation that went through. I participated in discussions about OWI laws as they relate to THC and other substances, and other controlled substance questions were often things that I visited the Capitol and had input on. And I think that having that experience also aids me in being an elected district attorney and representing the interests of St. Croix County in our legislature in Madison. Makes me a good partner for our local representatives in the legislature. And lastly, I think that it always helps someone as a leader to get away from the first place they worked. The first time I was a prosecutor, it was in St. Croix County. And I had a lot of really great and valuable experiences there, but it was also important to see other places, other styles of management, other styles of the justice system and how it operated, so that you could see both the good and the bad of what was going on. And I think that that also will be really valuable for me if I'm elected district attorney, is to have those different perspectives that I've gathered over my years of experience.
So Amber, thank you for that answer, very comprehensive answer on, your experiences and how it prepares you. So, one of the things in any election, people ask, what sets the candidates apart? And in this case, we have two candidates, both running as Republicans. Do you see partisan politics playing a role as the district attorney? Do you think it makes a difference that the primaries in the Republican Party versus Democrat, or if there had been a Democrat in this issue in this party, whether that would really impact this?
As I embarked on this decision to move forward and run for office, I took the opportunity to talk to a number of other elected district attorneys, some that have been in office a long time and some that have been in office a shorter time that I've just built relationships with over my career. And one of the questions I had for them is, how did they feel their party affiliation affected their role as district attorney? And because I really struggled initially with how does the political and partisan piece fit into being district attorney? Because my philosophy, or my view on what the district attorney is that our role as district attorney is to enforce the laws of the state of Wisconsin and of the United States in the jurisdiction of St. Croix County in this case. So I really feel that a lot of the partisan positions or partisan platforms relate to work that the legislature does. So as a district attorney, I don't see it as my role to make the laws of Wisconsin. It's to enforce the laws as they are. Now, certainly in any office or any profession, you can advocate for changes that you think are necessary in the law, but at the end of the day, you're enforcing the laws as they are. What I learned through talking to other district attorneys is there are some differences that the partisan positions do impact. As district attorney, and some of this, I didn't need to hear from others, you can figure that out on your own. As district attorney, we wield a wide range of discretion. Discretion in charging decisions, discretion in plea negotiations, and discretion in inevitably sentencing recommendations. And I think partisan views do play a part in that. I think one area that's sort of easy picking, so to speak, to bring up as an example is legalization of different controlled substances. I personally don't support the legalization of marijuana. I know that many people do, but currently in Wisconsin it is illegal. And so I would enforce the laws of Wisconsin as they are presently written. If the legislature changes course on that and they decide to legalize marijuana, then it would be my role to enforce the laws as the legislature has determined them. So I don't see partisan politics as playing a large role in the district attorney position, but I do think it would be disingenuous to say that it doesn't play any role at all.
Okay. You do mention, prosecutorial discretion. What would you consider to be your prosecutorial philosophy when it comes to, charging out matters? You get you don't get things always handed to you. Sometimes police believe that it's a certain charge and they bring it to you, but ultimately you have to be able to prove beyond a reasonable doubt and get a conviction. So what do you see as your general prosecutorial philosophy?
Sure. Well, the legal standard, of course, to charge a case is probable cause. So that's the bare minimum that must be there for charges to be issued. In the event that you have evidence and facts which support probable cause, there is a bit of a further analysis is where you sort of have to turn on your trial litigator's brain, so to speak, and look at that case and say, is this a case that a jury would find beyond a reasonable doubt that the crime was committed? And that certainly is a part of the assessment or a part of the philosophy or the approach that I would use. However, my personal philosophy is what I would describe as probably very victim-centered. Down the road, doing justice often means providing protection for the public as one of the factors we look at. And beyond that, it's providing justice to the victim and making sure that the victim rights are also being acknowledged. So between that probable cause level and that proving beyond a reasonable doubt, I think what also needs to be considered is what are the rights of the victims and what are the victims' wishes and what is best for the community and what is best for the public.
So how do you prioritize those?
I think, well, the first priority, of course, this has to be the legal standards. I mean, we have to follow the law. So first you have to meet the legal standard. And then once you've met the legal standard, then you have to look at those other considerations as to what is the overall justice in that case and what does that require? Does justice require that you take that case to trial and potentially lose the case or have a jury acquit? That could be the case. I certainly have taken cases that I haven't won. And being a district attorney isn't about winning, it's about doing justice. So I think that first, if you've met the legal standard, then the next thing to look at is what's best for the community and for the victim.
And have you seen, though, sometimes that not necessarily being one and the same? What's best for the victim or what's best for the community isn't necessarily the same, maybe, as what is being pushed by law enforcement, for example.
Absolutely. So, yeah. One of the experiences I can draw off of that I think illustrates the point that you're making, Jamie, is that as a part of the Sexual Assault Kit Initiative, one of our biggest missions in that project was first and foremost to be victim-centered. And the reason for that emphasis was largely because the victims as a part of that project had already had, in many ways, a misjustice in that their kit wasn't processed in a timely fashion and that we were going back to try to achieve justice at a later time. And one of the lessons or the things that I learned from being a part of that project is sometimes as a prosecutor, I would evaluate a case and had the legal standard. There was probable cause. I strongly believed that a jury would convict beyond a reasonable doubt. But when we reached out and talked to that victim, the victim said, you know what, this isn't what's best for me. This isn't what I want to do at this point in my life. And, I don't want to proceed with this prosecution. And in those cases, we absolutely adhered to the victim's decision and we didn't pursue that case. And I think that can be hard because on the one hand, you feel like pursuing that case was right for the community. Holding that offender responsible with a conviction was right for the community. But what was right for the victim in that particular case, because of the nature of the Sexual Assault Kit Initiative, outweighed in some ways that community responsibility.
Along those lines, I was pulling on my experience as a prosecutor. I recall having a case, it was child sexual assault, where the victim was 2.5 or 3 years old. It was right in that range. And so you had going to have extreme difficulty in getting a conviction. And so they always enter into that plea bargain, which prosecutors get chastised quite a bit for plea bargaining, but it does play a role. And so why don't you talk a little bit about the competing interest in plea bargaining, how you as DA might guide your office's decisions in those regards?
Absolutely. So when you start out and you look at a case, you have an idea for what you think justice is, what sentence you think would be appropriate to achieve in that case. And ideally, that's what you go forward in your plea negotiation with. You say, I think that the best outcome is for whatever that outcome to be, and you approach the defense. And if the defense says we don't agree, that's not something we're willing to engage in, then often that'll proceed to trial. In the midst of that situation are times when you sit down with the victims or you sit down with others and you talk about the case, and it's determined that while the ideal outcome was that first offered plea negotiation, when you look at the costs and benefits of going to trial, both for the victim and for the overall outcome of the case, there's a middle ground there, or there's a secondary offer that is going to be more of a benefit than the risk of going to trial basically outweighs the loss of going from what you initially offered to the secondary offer. And when that happens, then often the best opportunity is that lower plea negotiation. So it may look like, and it may be construed by others, that, a prosecutor is giving up or is not, going for what they should. But in reality, there's other factors there. Like you mentioned, when you have a very, very young child like that, it is unlikely many times, as we know as litigators, to get a conviction in cases like those. But it's more important for that child and for the community to have that person have some form of accountability, some form of supervision to hopefully ensure that nothing like that happens again. And so to get a plea bargain that achieves accountability, achieves rehabilitation for that offender, and achieves supervision and some protection for the community is a better outcome than going to trial, potentially losing, and that person having no accountability, no rehabilitation, and no supervision.
Right. Yeah, that you hit exactly on the head where in the case I was thinking of, we had the person that was, I think, leading the Department of Corrections, Probation and Parole, and his department writes the pre-sentence investigations and makes recommendations in that regard. He was pushing that this person was accused of sexually, touching or being touched by this 2-year-old, that person served lengthy jail as a condition of the probation. And I was caught in a dilemma of doing what they wanted, but yet, if the defendant didn't want to do the lengthy jail, I thought the more important thing was getting the conviction, getting the person labeled a sex offender was more important so that it would protect potentially other victims down the road.
Absolutely.
So with the, one of the areas too, charging, you hear a lot about overcharging. Prosecutor's office will bring like a felony and a Class A and a Class B misdemeanor for what it amounts to be a domestic assault. And if the person has no criminal background, could even be a deferred. What kind of factors do you look at then in order to determine, how hard you start with your charging and then where the case may end up?
Sure. Well, first and foremost, when charging, I like to pull jury instructions, because what you want to look at, obviously you look at the statute, but often a more clear thing to look at is the actual elements that you have to prove. And so first you want to make sure that your facts and your evidence support the proving of each and every element of any offense that you're contemplating charging. The second thing that I would usually look at is I try to look at it with my quote unquote litigator's brain, which is if I am presenting this case to a jury trial. When you're doing a jury, often you want a narrative or a story, for lack of a better word, which is supported by the evidence. And so you look at the case and you say, what charges most appropriately fit the narrative? So if this is a domestic violence case, how do you tell the story of these individuals and this crime, this event that happened, and what charges support the telling of that narrative or help you tell that narrative? And then, of course, you also need to look at what's most appropriate here. Is this a situation where you could charge 25 things, but that's, you know, really in excess of what justice demands, and 2 would be sufficient? Or is this a situation where the all 3 pieces align and it supports, you know, a certain number of charges, whether that be 2 or 5 or whichever? And then I also think, to a smaller degree, there should be some consideration for potential penalty. So you have to look at what is ultimate justice in this case. What resolution do you think this case provides for the best outcome for the community? And then what charges and associated penalties support the achievement of what your desired outcome is?
So you've prosecuted in different counties, and you were in St. Croix County for 5 years. Are there policies that you've seen in those other counties or where you practiced that you think would be useful in St. Croix County, what you would try here? Or are there policies that you experienced as a St. Croix County assistant prosecutor and then maybe thought that you would do it differently when you became head DA?
Sure. I think felony cases in general are too individual for a like blanket policy, and so need to be handled more on a case-by-case basis. I do think that policies, and I've seen these across the state, both in the St. Croix County office and other offices I've worked in, involving misdemeanors or more common offenses such as operating while intoxicated, possession of drug charges, so like possession of THC, for example, possession of drug paraphernalia, those types of low-level drug offenses, or operating while intoxicated offenses. Often having policies in those types of cases, I think, supports consistency and fairness. For example, if you are an OWI second offense, you know, not involving any injury or damage to property, and you know, no accident, no egregiously bad driving, you know, whether you're person A, person B, or person C, that type of offense can be handled similarly across the board. And so I think that there are policies on OWIs, policies on low-level drug offenders to address, first and foremost, on low-level drug offenders, rehabilitation. And the focus should be on helping that person to be law-abiding. So addressing the addiction issue if there is one, and encouraging that person to seek services and become law-abiding by helping them with their addiction issue. Those types of policies I would continue, and I think are well supported both by evidence and also by my experience, just that's a better outcome for the community. But I don't support sort of blanket or across the board treating every case the same policies in most felony offenses, because I just think there's too many variables there.
Right, and not to mention the individual offender's criminal history is one of the top considerations, I would imagine.
Yes.
So when it comes to reducing crime and increasing safety, which would be the goal of law enforcement in general, what do you see your role as the head DA being able to impact those things?
So first of all, I'm a big believer in establishing relationships and having trust. And one of the things that I really loved about St. Croix County when I worked here, and you know, worked here 5 years ago, and then one of the reasons I wanted to return is that, and I don't know if everyone in St. Croix County has the same viewpoint that I do, but in the experience that I've gathered, St. Croix County has some of the most outstanding law enforcement in the state of Wisconsin. And I think that we should be really proud and thrilled to have that resource. And as district attorney, I'd like to keep and maintain a positive relationship with law enforcement, a relationship built on trust, not because, you know, I don't want to be a yes person, that, you know, I'm not saying trust in that law enforcement will trust me to do whatever they want me to do, but instead to know that I'm going to tell it to them straight, that I'm going to be a resource for them, both on the law and on how to help them in training, and then extend that to the community. Participation in CJCC, participation in service providers in the community, establishing those relationships so that we can partner as a district attorney's office in overall engaging in increasing safety in the community. And I think that has to start with a strong relationship with law enforcement. And I think that that goes in some way to some of the present issues we're seeing with some tensions between law enforcement and certain portions of the community. And I think that that really has to start as a district attorney with having a strong relationship with law enforcement.
Okay, and thank you for that. You were getting to the segue that I wanted to, touch upon. This whole notion of defund the police or a need for drastic police reform. That may be true in certain areas. Do you see it as a need in St. Croix County?
Absolutely not. As I said before, we have great law enforcement in St. Croix County. And in any profession, you're going to have people that do the job to different levels. So I don't think we should ever charge an entire profession by the actions of one person or even a couple people. However, if there is a problem, there needs to be a strong, open communication, and there needs to be a strong relationship so that as district attorney, if there is a problem, you know that it's going to get addressed appropriately. Now, if there's ever a problem in St. Croix County, the St. Croix County District Attorney's Office, of course, would not be appropriate to prosecute that case if it would rise to a level of criminal action. But it's knowing how to take appropriate steps to get someone involved to evaluate that case and take care of it as need be. But I don't think that defunding the police is the way to go. I think that we have amazing and awesome law enforcement officers, and they need support and training and appreciation. And as district attorney, if I'm elected, I fully intend to support those positive relationships and be a positive influence with them. It's not to say that there can't ever be a problem and that there can't ever be someone in, St. Croix County law enforcement that maybe has a criminal action. It's not to say that. It's to say that when there is that problem, both the district attorney's office and law enforcement can work together to resolve that issue in a way that's going to be protective to the community. But I don't think the answer is to abolish or get rid of police or defund police.
And Amber, one of the areas that can be touchy is, the legislature. Anybody who's been a prosecutor for more than a decade, such as yourself, you've seen changes in the way that certain offenses are dealt with. Drunk driving being the most common one. It seems like every single legislative session, somebody tweaks, whether it's minimum penalties, maximum penalties, or something, trying to take away both judicial and discretion within the justice system on how something is dealt with. And do you see, of those changes where lower number of convictions necessary to get a felony conviction or minimum jail terms on drunk driving, we've seen some DA offices go to the use of probation for multiple offense drunk driving. So how do you see the role of being the head prosecutor and setting policies with enforcing the laws that are getting changed and passed in Madison?
Sure. Well, as I've said before, I view the position of district attorney as to enforce the laws as the legislature has set them. So if the legislature deems and passes a change, then it's my job as district attorney to enforce the law as it exists in Wisconsin at that time. And so I do believe that's how I would treat that. On a policy side of things, where there is discretion to be exercised, then I think it depends greatly on the situation and what type of law you're talking about. But I also think there's an opportunity, like I kind of mentioned, relationships that I've built in Madison over the years, and working with legislators, there's always an opportunity to educate the legislature in the areas of criminal justice that they may not be experts in. and that was sort of my role at DOJ. Was, in a way, I was the expert on prosecution, and I would come in legislative situations and try to provide education and information to legislatures about how certain provisions or how certain words in statutes affect the criminal justice system and the outcome, to make sure that legislators are writing laws that are going to achieve the goals that they think they're achieving. So sort of providing that practical or logical side of things. And I think as district attorney for St. Croix County, I can still be that advocate, and I can still attempt to be that educator if the legislature is considering changes to statutes that, we either support or don't support, or just thinks that the legislature needs more information. I think that too can be a part of the district attorney's role to provide that education.
Okay. And forgive me there, I have a little bit of cough, picked up a cold from the grandkids. So last question would be on that whole notion of prosecutorial discretion, but the diversion programs and the drug treatment court we have in St. Croix County. Do you see those as historically having been successful or not successful or need improvement? And what do you think of the use of those and how it plays overall in addressing public safety?
Sure. Well, I think what we've learned over time is, and especially in the last sort of 5 years or more, the criminal justice system has become much more sensitive to the use of data and collecting data about our outcomes, about our incomes, and sort of how the system, what the inputs are and what the outputs are. And I think that treatment courts are a result of sort of that learning process. And in St. Croix County, I served on the drug treatment court for the 6.5 years I was there. So I was a member of that drug treatment court basically from day one to my last day in St. Croix County. And overall, I think that program provides a big benefit to the community. With drug addiction in particular, we can really do a lot with treatment courts to rehabilitate people. And in the end, that's going to decrease crime in the community. Another example of sort of how data can help improve the criminal justice system, I think, is the Day Report Center. That came into play after I left St. Croix County, but from the information I've gathered from community partners, it's been really successful in helping individuals in the criminal justice system maintain sobriety. And by maintaining sobriety, it's been helpful in keeping crime down. And so I think that treatment courts, the Day Report Center, have provided good results for the community. And I think we can continue to support those programs while also continuing to look at the data. We need to continually look at our input and our outputs and adjust programs as needed. Nothing stays static, everything changes over time, and treatment courts need to do the same. As for the diversion program, I think that's also a valuable piece of the puzzle. We've learned a lot about brain development in juveniles and adults. And there's a lot of people that enter the criminal justice system in sort of that 17 to 25 year age group. A lot of times they're low-level drug offenders. A lot of times they're low-level misdemeanor offenders. And there's a lot of room at that point in a person's life to come in and try some rehabilitative efforts before that person is saddled with a criminal record for the rest of their life. And so I think the diversion program both helps with the efficiency of the court system by weeding out some of those cases that are not as important to go through the process, and that we can achieve good outcomes through a diversion program, as opposed to having all those cases enter into the criminal justice system and take away from other more important cases, that need the court's time. So I think that the diversion program is also a valuable program to continue.
Okay. Well, Amber Hahn, thank you very much for your time. Thank you for coming on the show. And help me out here, because I was about to tell the folks, this race for district attorney in St. Croix County is basically a contested primary. Wisconsin has open primaries, so you don't need to be necessarily a registered Republican vote. But people do need to vote in the Republican Party's primary in order to have a voice on who's going to be district attorney, because there will be no contest come November, correct?
Yes, that's correct. Yep, it'll be the determination of who will be unopposed on the general election will occur on August 11th. So it's important that people cast their votes if they want to have a say in who the District Attorney of St. Croix County is going to be.
All right. Thank you for reminding us of the date. That's August 11th, folks. And thank you, viewers, for watching another segment of Western Wisconsin Journal. I'm Jamie Johnson. Thanks for watching.